All right, guys, buckle up because today we're watching a routine court appearance turn into a slow-motion collapse of fantasy law. What starts as a simple case call quickly becomes a clash between courtroom reality and a defendant who refuses to play by any rules except her own.
All right, we are on the record in case number 25 TRD 01258, captioned the State of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Ms. Yeager is here on behalf of the State of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under a OVI suspension, and the other is driving under a on the citation, but according to the new Albany Municipal Code, it's basically just driving under a forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to a $1,000 fine, and up to a 1-year license suspension. Does carry mandatory minimum penalties of up to, or of at least $250 fine, a 1-day license suspension, and at least 3 consecutive. Charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be one conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have a document served the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been passed up from the clerk, and as well my case is in fact on an appeal at the moment.
The case is called, and immediately the tone is set. The judge lays out the charges plainly, but the defendant signals trouble by rejecting standard procedure. Instead of answering directly, she deflects, questions authority, and hints she's operating under a different system entirely. This first exchange makes it clear the court is dealing with resistance, not confusion.
Appeal where?
I'm sorry.
On appeal where?
It's an appeal.
In what court? That's what I'm saying. Where have you filed an appeal?
The Court of Appeals.
Okay, which district?
District.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th District. You're absolutely right. 5th District.
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court.
That one, or this?
But just in general, all of your filings with this court are on this. It's kind of a unique. The documents are unique in that they're gray and they're typed in all caps, and one of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division. And this is obviously Newark. Mr. Mackey, you do have the right to have a trial by jury, but in order in what we call a petty offense, and a petty offense is anything punishable by less than 1 year in prison, a jury trial, it has to be demanded, and Rule 23 of the Ohio Rules of Criminal Procedure require that jury demand be made not less than 10 days before the scheduled bench trial. So your request for a jury trial would be untimely.
Here, the defendant claims the matter is on appeal and suggests the court lacks authority. The judge presses for clarity, asking basic questions about filings and jurisdiction. Each answer creates more contradictions. What's striking is how calmly the judge keeps control while the defendant digs herself deeper by failing to explain anything in legal terms that actually exist.
Now, I'll entertain a position from the state in that regard. Do you intend to represent yourself throughout, whether you have a bench trial or a jury trial? Or did you want the court to, or are you going to ask the court to appoint an attorney to represent you?
Represent myself, Your Honor.
Okay. Well, I'm going to deny what I construe to be a motion to continue for the purpose of setting the matter for jury trial because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the motion was made, but the court denied that. Your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to...
The judge addresses the jury demand and shuts it down as untimely. The ruling is clean and procedural, but the defendant reacts as if it's personal. This moment shows the divide clearly. The court is following deadlines and statutes, while the defendant believes saying the right words should override the process.
Change your pleas from not guilty to guilty or no contest.
Your Honor, if it pleases the court, I motion that this case be continued and or stayed because the case is now on an appeal in the 5th District Court of Appeals. Also, the case has been petitioned removed to the Ohio District Court under case 223 CV 02962 JLG CHG and to the New Jersey District Court under case 22 CV 03934 LEFJBC. The court's jurisdiction is divested until those courts determine otherwise.
Well, actually...
The defendant moves to stay the case, citing vague federal filings and supposed jurisdictional barriers. The judge listens, then explains why none of it applies here. It's a textbook moment of law versus ideology, with the court grounding every response in rules while the defendant leans entirely on belief.
Number one, your paperwork from that purports to be from the federal district court doesn't look like pleadings from the federal district court. They're plain white paper with the case number in blue up at the top of the page, and that's not how yours are captioned. Furthermore, as far as jurisdiction is concerned, have jurisdiction because this is an alleged violation of the traffic laws of the city of New Albany that is alleged to have occurred within Licking County. This court has jurisdiction over traffic offenses that are alleged to have occurred within Licking County, and by being here today and by entering pleas, you've waived any personal jurisdiction over you. All right?
Your Honor, I object on this bench trial. I do want a jury trial.
Okay, and as I've already explained to you, you did not make your timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me...
Frustration builds as the judge explains jurisdiction again, slowly and clearly. The defendant keeps interrupting, refusing to accept the answer. This exchange highlights how courts don't argue philosophy. They rule. No matter how often the defendant circles back, the outcome doesn't change.
Me, like, you don't want to, I know you don't want to change your pleas from not guilty to guilty or no contest. So at this time, I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Course to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat, but Mr. Mackey, you indicated that yourself, correct? Is that right? Okay. So you have the right to be represented by an attorney by hiring one of your choosing. You're also eligible to ask the court to appoint an attorney to represent you at no cost. If you qualified based upon your income, your expenses, your household size, the court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to count 5-8. So I'm going to have the bailiff hand to you a form entitled attorney waiver. I'm just going to read it into the record in open court right now. It says, it's captioned attorney waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by qualified. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So it is your intention to represent yourself and to waive your right to an attorney.
Yes.
Go ahead and sign by the X there, but do please read that because I'm going to make sure that you understand what it is.
When asked about waiving counsel, the defendant refuses to cooperate with the process. The judge makes a constructive waiver ruling on the record. This is a quiet but critical moment. By rejecting the formality, the defendant loses protection, all by her own choice.
Please swear in the witness.
Do you solemnly swear or do you affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I affirm.
Please have a seat, sir. For the record, you're going to give your name and spell your last name.
Officer Michael Coors, C-O-H-R-S.
And the address of your precinct?
50 Village Hall Road, New Albany, Ohio, 43054.
Thank you, sir.
Thank you. You may inquire.
Officer Force, how long have you been with the New Albany Police Department?
Over 6 years.
And were you so employed on January 29th of 2025?
Yes.
And were you working that day?
Yes.
What shift or hours were you working?
Damn.
And were you wearing a uniform of the day like you are in court?
Yes.
And were you driving a marked cruiser with a working visible light bar?
Yes.
And what were your duties that day?
I was working standard patrol. I would believe I was on Zone 3, which is the Licking County side of New Albany.
Is that for like traffic enforcement?
Correct.
And what kind of training have you undergone for traffic enforcement?
I was trained at the Columbus Police Academy over 2 weeks of traffic enforcement to include all traffic laws and proper traffic stops.
And as of January 29th of 2025, were you up to date on all continuing education, training, and certification requirements?
Yes.
We're going to draw your attention to about 4:50 p.m. Whereabouts were you on patrol at that time?
I was on Beach Road heading southbound just north of State Route 161.
And is that in the city of New Albany in Licking County, Ohio?
Yes.
While on patrol, what first drew your attention to the defendant's vehicle?
As he was traveling northbound, making a left turn onto the State Route 161 westbound on-ramp, I observed he had dark tinted windows, which initially drew my attention. And then as he passed me, I made the right-hand turn, drove behind him, and entered his...
When you ran that, return anything?
It did. It turned through my mobile computer, through our leads program on there. I observed that his license plate had expired, or registration, I should say, expired on July 8th of 2024.
And so when you approached the defendant for the stop, did you inform him as to the reason for your traffic stop?
I did.
And did he have anything to say about that?
He stated he was aware that the registration had been expired.
Okay. And did he have a driver's license for you too?
He had an identification card.
An ID card? Okay. Were you able to then go back to your mobile unit status?
Yes.
And what did that return?
I observed again through my computer system that it showed he had multiple active suspensions, one of them being the OVI suspension that he was cited with, as well as the 2 non-compliance suspensions. On my system, the reason why it was shown on the citation as a security suspension, that was the label, but per what I read through the system there, it was the financial liability.
Nothing further for this witness at this time, Your Honor.
All right. So, Mr. Mackey, you have the right to ask.
An officer testifies, laying out the facts, expired registration, license issues, and the basis for the stop. Unlike earlier chaos, this section is grounded and factual. The contrast is sharp. Evidence speaks clearly, and no amount of rhetoric can undo documented violations.
This question witnesses. You have the right to ask this witness questions if you wish, but you're not required to. And once the state's rested its case, you'll have the right to present evidence on your own behalf. But this portion of the trial is just for questioning. Do you have any questions for the officer?
No.
Any additional witnesses on behalf of the state?
No, Your Honor. Subject to the admission of Plaintiff's Exhibit 1, the state would rest.
All right. So, Mr. Mackey, the state is asking me to admit the certified BMV records into evidence. If I grant that request, that means I'll be able to consider that about whether or not the state has met its burden of proof beyond a reasonable doubt. You have the right to object to whether or not that comes in. Do you have any objection to the court admitting that as an exhibit?
To this bench trial, Your Honor, I do. Up to this bench trial, Your Honor.
Okay, well, we've discussed that already, Mr. Mackey, so at this time, I'm just asking whether or not you have an objection to the admission of the exhibit.
Yes.
And on what basis?
This court does no longer has jurisdiction, Your Honor.
Okay.
I respectfully.
Well, that's non-responsive to the court's question. I'm going to go ahead and I'm going to reflect that the defendant is objecting to the admission of State's Exhibit 1, but I will admit that over the defendant's objection. Does the state rest?
Yes, Your Honor.
All right. Now, Mr. Mackey, the state, in our system of justice, it's always the prosecution's burden to prove guilt beyond a reasonable doubt before a person can be convicted. A defendant is never required to produce any evidence, call any witnesses, introduce any exhibits into the record, or even testify on their own behalf. And if they don't, I don't hold it against them. It doesn't lessen.
The judge gives a defendant a chance to object or present evidence. She doesn't. Instead, she deflects again. This silence matters. In court, failing to act is often the same as agreeing, and here it closes the door on any real defense.
You know, we're recording all this. You'll certainly have the right to obtain a transcript of the proceedings and pursue your appeals regarding the jurisdiction issue. But again, my question that I'll ask one last time is, do you wish to testify on your own behalf? Well, the court's heard testimony from Officer Kors, which finds to be credible, that he was on duty on the date in question, that he executed a traffic stop upon discovering that the registration on the vehicle was expired, that he made contact with the driver, who he's identified as the defendant, and reviewing the information provided by the Bureau of Motor Vehicles, determined that he was under both an OVI suspension as well as a Financial Responsibility Act suspension. The court, furthermore, has admitted into evidence over the defendant's objection, admittedly, a certified copy of the defendant's driving record through the Bureau of Motor Vehicles, and it does in fact list both the noncompliance suspension as well as the OVI suspension, and reflects the expiration date of the registration as being prior to the date of the traffic stop. So I do find that the state has met its burden on all three counts, and I'll go ahead and enter guilty finding.
The judge delivers guilty findings on all counts. The explanation is calm and direct, tied to testimony and records, not opinions. This is the inevitable result of ignoring procedure and refusing to engage with reality. The decision lands without drama because the path was already set.
It's about their personal circumstances. If you don't want to answer, that's fine. Do you work? Do you have a job?
Yes, Your Honor.
What kind of work do you do?
HVAC, sheet metal, as I told the officer that had pulled me over.
Is that what you were doing that day? You were working out at the warehouses? Okay. Do you work for yourself? Do you work for yourself or do you work for a company?
I work for a company.
Okay. How long have you worked for them?
It's been 3 years. I've been in a steel.
Here's the thing. One of the reasons why I'm asking you these questions today is, as I mentioned earlier at the beginning of our proceedings, the court is required to impose at the very least a 3-day jail term. I don't want to cost you your job. Do you work Monday through Friday?
Saturday, Your Honor.
Monday through Saturday? We normally do not have, well, let me go ahead and pronounce the sentence first, and then we'll talk about that. When you got pulled over that day, Mr. Mackey, you were just given your citation and then you were free to go, right? They didn't take you to jail, did they?
Correct.
Okay. All right. As far as the registration is concerned, the fine on that charge is going to be charged. The court's going to impose a 3-day jail term, a $250 fine, and a 1-day license suspension to be start today and as of midnight. Costs will be assessed. Now, the reason I was asking you about your work and everything else is, as I said, I don't want to cost you your job, Mr. Mackey, but I don't have any discretion when it comes to those 3 days in jail. Normally, we require defendants, so it's customary for the court to grant what we call report dates. Some courts call them enforcement dates. And typically, we require that the defendant report here to the courtroom. But since my colleague, Judge George, took the bench, we now have the option of having folks report directly to the jail. And that's important for one reason. If you had to report here, you'd have to report on a day that the court's open, so Monday through a Friday. All days of you report to the jail on a Sunday, at least one of those days, of the 3 days, you won't be missing work, okay? Would you like for me to grant you a report date to the jail on a Sunday? I mean, I know you don't want me to impose any jail at all, but under the circumstances, would you prefer that I make it so that you report to the jail on a Sunday so you only miss 2 days of work? Okay. All right.
Sentencing follows, including penalties and clear instructions. The judge issues a warning about future conduct, making it clear this system will not bend to personal theories. And that wraps it up. If you found this breakdown useful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.